Hello Year 11s and welcome to this video on the Victorian Civil Court hierarchy. There are 4 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you want to go over any information contained in this video. The third thing that you need to do is to have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms or of any other words the meaning of which you're unfamiliar with. And the fourth thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you guidance as to what you should write in your summary books. Once you've finished watching and taking notes on this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then make sure that you supplement your Cornell notes with that additional information. Well, let's get started then. Here are the learning intentions for this video. Make sure that you write these learning intentions down in your Cornell notes. By the end of this video, you should be able to do 2 things. The first thing is that you should be able to describe the civil jurisdictions of the Victorian court hierarchy. The second thing that you should be able to do is explain the reasons for a Victorian court hierarchy in determining civil cases, including administrative convenience and appeals. In Unit 1, we looked at the Victorian criminal court hierarchy. As we work through this video, you will see that there are a number of similarities between the Victorian civil court hierarchy and the Victorian criminal court hierarchy. A very good way then of learning this material is to learn those similarities. However, there are also some very important differences, and you must be careful not to confuse the Victorian criminal court hierarchy with the Victorian civil court hierarchy. Here are 4 very important definitions that you should be familiar with from our work on the Victorian criminal court hierarchy. In your vocabulary sheets, look down the left-hand side, find each of these defined terms, and opposite the relevant term, write in the corresponding definition. The first term that you need to be able to define is court hierarchy. A court hierarchy is the ranking of courts according to the seriousness and complexity of the matters they deal with. In your definition, highlight the words ranking and seriousness and complexity, and if ever you're asked to define the term court hierarchy, make sure that you use those highlighted words in your definition. As you know, the High Court is at the top of each of the state and territory court hierarchies, including the Victorian civil court hierarchy. The High Court deals with the most serious and complex cases. This is because parties are only likely to appeal a case all the way to the High Court where that case is a very significant case and the case involves difficult questions of law. Also, because the High Court is at the top of each of the state and territory court hierarchies, its decisions are very important as there is no appeal from them. This is because there is no court above the High Court which could hear appeals from High Court decisions. This puts the High Court in a very special and powerful position. On the other hand, the Magistrates' Court is at the bottom of the Victorian civil court hierarchy because it only deals with small civil disputes. In addition, because the Magistrates' Court is at the bottom of the Victorian civil court hierarchy, the Magistrates' Court doesn't hear appeals from any court. There is no court below the Magistrates' Court from which an appeal could be made to the Magistrates' Court. The second term that you need to be able to define is jurisdiction. Jurisdiction is the extent of the power of a court. That is, the jurisdiction of a court refers to the types of cases that the court can deal with. In your definition of jurisdiction, highlight the word power and make sure, if you're ever asked to define the term jurisdiction, that you include that highlighted word in your definition. So, as you'll see soon, the Magistrates Court has the jurisdiction or power to deal with civil disputes of up to $100,000. The Magistrates Court does not have the jurisdiction to deal with civil disputes of more than $100,000. So you'll never see a civil dispute for, say, $5 million being dealt with in the Magistrates Court. Now, there are two kinds of jurisdiction. The first kind of jurisdiction is original jurisdiction. A court is said to be exercising original jurisdiction when it is the first court to hear that case. That is, original jurisdiction is the power of a court to hear a case for the first time. In your definition of original jurisdiction, please highlight the words power and for the first time. And remember to use those highlighted words wherever you're asked to define original jurisdiction. So, for example, the Magistrates Court has original jurisdiction to hear civil disputes of up to $100,000 because when a plaintiff sues a defendant for an amount of $100,000 or less, the plaintiff can bring this case to the Magistrates Court. The second kind of jurisdiction is appellate jurisdiction. A court is said to be exercising appellate jurisdiction when it hears an appeal from a lower court. That is, appellate jurisdiction is the power of a court to review the decision of a lower court. When a court hears an appeal, it is reviewing the decision of the lower court to correct any mistakes that the lower court has made. In your definition of appellate jurisdiction, please highlight the words power and review. If you're ever asked to define the term appellate jurisdiction, make sure that you use those highlighted words in that definition. You'll note that we don't simply define appellate jurisdiction as the power of a court to hear an appeal. That would be circular. It doesn't demonstrate that we know what appeal means. That's why we use the word review. Now remember that, even though a party will often appeal the decision of a court with original jurisdiction to a higher court, it's also possible for there to be an appeal from the decision of the court that hears that appeal. So, in other words, it is possible for a case not just to be heard a second time, which is where there is an appeal from the court with original jurisdiction, but the case might also be heard a third time. That is, when there is an appeal from the court that hears the appeal from the court with original jurisdiction. In fact, there might yet be another appeal, which means that the case is heard for a fourth time. For these reasons, it is not correct to say that appellate jurisdiction is the jurisdiction to hear a case for a second time. As I've said, a case could be heard for a second time, but it could also be heard for a third or even a fourth time. That's why we define appellate jurisdiction simply as the power of a court to review the decision of a lower court. An example of appellate jurisdiction is the jurisdiction of the Court of Appeal. In fact, the Court of Appeal only hears appeals. In particular, it hears appeals from decisions of the County Court and the Trial Division. For instance, let's suppose that a plaintiff sues a defendant for negligence in the County Court and that, at the trial in the County Court, the verdict is that the defendant is liable to the plaintiff. Let's further suppose that the judge, or the jury if there is a jury, decides that the amount of damages the defendant should pay the plaintiff is $5 million. If the defendant thinks that this amount of damages is too high, then the defendant can appeal against that amount of damages to the Court of Appeal. If the Court of Appeal agrees with the defendant that the $5 million in damages is too high, then the Court of Appeal will reduce the amount of damages that the defendant has to pay to the plaintiff, say to $3 million. This is an example of the Court of Appeal exercising appellate jurisdiction. The Court of Appeal reviewed the decision of the County Court and corrected the mistake made by the County Court, which was to decide an amount of damages that was too high. Note that the appeal is brought by the dissatisfied party, in this case by the defendant, who is dissatisfied with the amount of damages that has been awarded by the County Court. You must never say that a court appeals its decision to another court. It is a party who appeals a court's decision to a higher court. Let's now look at the Victorian civil court hierarchy in a bit more detail. You'll see that the 5 courts that make up the Victorian civil court hierarchy are exactly the same as the 5 courts that make up the Victorian criminal court hierarchy. So, at the bottom of the Victorian civil court hierarchy, we have the Magistrates' Court. Civil proceedings in the Magistrates' Court are called hearings. Above the Magistrates' Court, we have the County Court, and above the County Court, we have the Trial Division of the Supreme Court. Civil proceedings in the County Court and the Trial Division are called trials. Above the Trial Division of the Supreme Court, we have the Court of Appeal. Now remember that both the Trial Division and the Court of Appeal are separate parts of the Supreme Court. The difference is that the Trial Division, as its name suggests, hears trials of civil disputes. On the other hand, the Court of Appeal, as its name suggests, deals with appeals. And finally, at the very top of the Victorian civil court hierarchy, we have the High Court. The High Court is a federal court, unlike all of the other courts in this diagram, which are Victorian courts. There is only one High Court in Australia, and it sits at the top of each state and territory court hierarchy. In this slide, I will set out in diagrammatic form the original jurisdiction and the appellate jurisdiction of each of the courts in the Victorian civil court hierarchy. This is a very important diagram which you need to include in your summary books. It will provide you with a very useful point for revising your knowledge of the original and appellate jurisdictions of each of these courts. Starting at the bottom of the hierarchy, we have the Magistrates' Court. The original jurisdiction of the Magistrates' Court in civil disputes is to hear claims of up to $100,000. Put another way, the Magistrates' Court deals with small civil disputes. And that's appropriate because where a dispute is small, it can be dealt with more quickly and more cost-effectively in the Magistrates' Court. Because the Magistrates' Court is the lowest court in the Victorian civil court hierarchy, it has no appellate jurisdiction. There is no court below the Magistrates' Court from which appeals can be brought to the Magistrates' Court. Moving up the court hierarchy, we come to the County Court. The original jurisdiction of the County Court in civil disputes is unlimited. That means that the County Court can hear civil disputes of any amount. That is, where the amount that's in dispute is anywhere from $0 right up to millions and millions of dollars. In theory, this means that a party that has a civil dispute of less than $100,000 could bring that civil dispute in the County Court rather than in the Magistrates' Court. But the fact is that parties generally don't do that because it is more expensive and takes more time to have civil disputes resolved in the County Court than in the Magistrates' Court. Now, unlike in the Victorian criminal court hierarchy, in the Victorian civil court hierarchy, the County Court has no general appellate jurisdiction. That is, it doesn't generally hear appeals in civil disputes from the Magistrates' Court. there are some acts of the Victorian Parliament that specifically provide for an appeal in a civil case to be heard by the county court, but these are only in a fairly limited range of civil disputes. So, for our purposes, we say, when we're talking about civil disputes, that the county court has no general appellate jurisdiction. We now come to the trial division of the Supreme Court. The original jurisdiction of the trial division in civil disputes is unlimited. That is, the trial division has the same original jurisdiction as the county court in civil disputes, which is the jurisdiction to hear civil disputes of any amount. This includes the jurisdiction to hear civil disputes of less than $100,000. But again, parties are unlikely to bring such a small civil dispute to the trial division because it is more expensive and more time-consuming to have civil disputes resolved in the trial division than in the magistrates' court. Now you might ask, well, given that both the county court and the trial division have the same original civil jurisdiction, how do we know whether it's the county court or the trial division that will hear a particular civil dispute? The answer is that it's up to the plaintiff, that is, the party that brings the civil dispute to court in the first place. So, it's for the plaintiff to choose whether to bring their civil dispute to the county court or to the trial division. In making their decision, the plaintiff will take into account things such as the complexity of the civil dispute and the costs that the plaintiff is willing to bear in bringing that dispute to either the county court or the trial division. The trial division also has appellate jurisdiction in civil disputes. In its appellate jurisdiction, the trial division is able to hear appeals on points of law from the magistrates' court. That is, where a party believes that the magistrate has made an error of law or has misapplied the law, then they're able to appeal from the magistrates' court straight up to the trial division. Above the trial division, of course, we have our Court of Appeal. As I've said before, the Court of Appeal has no original jurisdiction because its role is simply to hear appeals. Therefore, it only has appellate jurisdiction. The Court of Appeal hears appeals in civil disputes from both the county court and the trial division. To be able to bring an appeal to the Court of Appeal, that appeal has to be on a point of law, that is, that the county court or the trial division has made an error of law or has misapplied the law, or it has to be an appeal on a question of fact, that is, that the county court or the trial division has misinterpreted or perhaps overlooked significant facts, or that appeal has to be about the amount of damages that have been awarded in the county court or the trial division. For example, the plaintiff might appeal to the Court of Appeal from a decision of the county court or the trial division to award a particular amount of damages to the plaintiff where the plaintiff thinks that that amount of damages is too low. Conversely, the defendant might appeal to the Court of Appeal from a decision of the county court or the trial division to award a particular amount of damages to the plaintiff where the defendant thinks that that amount of damages is too high. We now come to our second learning intention. This learning intention is that you should be able to explain the reasons for a Victorian civil court hierarchy, including administrative convenience and appeals. You may remember that there are actually 4 reasons for a court hierarchy, that is, specialisation, appeals, administrative convenience, and precedent. However, according to the curriculum, the 2 key reasons for a Victorian civil court hierarchy are administrative convenience and appeals. And so these are the 2 reasons that we'll be focusing on and that I want you to use if you're answering a question in a SAC or exam about the reasons for a Victorian civil court hierarchy. This is different from the Victorian criminal court hierarchy, which we looked at in Unit 1. In that case, the curriculum emphasises specialisation and appeals as being the two key reasons for a Victorian criminal court hierarchy. This brings me to an important point that often trips students up. Read the question carefully. If the question is asking about the reasons for a Victorian civil court hierarchy, then make sure that any examples you give relate to the Victorian civil court hierarchy. If the question is about the reasons for a Victorian criminal court hierarchy, then make sure you give examples that relate to the Victorian criminal court hierarchy. Of course, if the question just relates to the Victorian court hierarchy, you can use examples from either the Victorian civil court hierarchy or the Victorian criminal court hierarchy. The table on this slide and the next slide describes and explains administrative convenience and appeals as reasons for having a Victorian civil court hierarchy. Please copy this table into your summary books and supplement this table with any additional information that you think will help you remember and explain the reasons for a Victorian civil court hierarchy. You will see that we can explain these two reasons by using the counterfactual if there was no civil court hierarchy then. This is a good technique for answering a question about the reasons for the Victorian civil court hierarchy because it highlights the advantages of that court hierarchy by highlighting the disadvantages if there was no court hierarchy. In a moment, I will show you what I mean. As I've said, the first reason for having a Victorian civil court hierarchy is administrative convenience. Administrative convenience means that more complex and serious cases are heard in higher courts, while more simple and minor cases are heard in lower courts. Look down the left-hand side of your vocabulary sheets, find the term administrative convenience and write this definition in there. Administrative convenience focuses on the fact that the higher courts, such as the County Court and Trial Division, deal with cases that are likely to take a longer time to resolve because those cases are complex and serious cases. That is, they are large cases. Whereas the lower courts, such as the Magistrates' Court, deal with cases that are likely to take a shorter time to resolve because those cases are simpler and more minor. That is, they are small cases. This is administratively convenient because if both large cases and small cases were dealt with by the same court, then the large cases would hold up the resolution of the small cases and so create a backlog in these small cases. It's therefore more efficient to stream larger cases to the higher courts, such as the County Court and the Trial Division, and smaller cases to the lower courts, such as the Magistrates' Court. Whenever you are describing administrative convenience as a reason for the Victorian civil court hierarchy, try to remember to describe it using the words backlog and efficiency as I have just done. It's very important that you can use examples to illustrate how the Victorian civil court hierarchy achieves administrative convenience. Here are two examples. The first example is that the Trial Division and the County Court have unlimited jurisdiction to hear civil disputes. Large civil disputes can be very complex and involve millions of dollars. It is more efficient for these kinds of disputes to be dealt with by the Trial Division and the County Court, while smaller civil disputes are dealt with by the Magistrates' Court, because otherwise these large civil disputes would delay the hearing of the smaller civil disputes. The second example of administrative convenience is the flip side of the first example, namely that the Magistrates' Court only deals with civil disputes of up to $100,000. In other words, the Magistrates' Court only deals with small civil disputes. This is efficient because if the Magistrates' Court also had to deal with large civil disputes, then these large civil disputes would delay the Magistrates' Court in dealing with the small civil disputes. So, how is administrative convenience a reason for having a Victorian civil court hierarchy? Well, we can explain this using the counterfactual if there was no civil court hierarchy then. Bringing together the explanation I've given you, including the important concepts of efficiency and backlog, we could say, if there was no civil court hierarchy, then administrative convenience would not be achieved because one court would deal with both large and small cases. This would not be efficient because the court would be delayed in hearing and resolving the large number of smaller cases while it was dealing with the larger cases. As a result, there would be a backlog of smaller cases. Let's now look at the second reason for having a Victorian civil court hierarchy, that is, appeals. In an appeal, a party that is dissatisfied with the decision of a lower court requests a higher court to review the decision of the lower court so that the higher court can correct any mistakes in the lower court's decision. Look down the left-hand side of your vocabulary sheets, find the word appeal and write this definition in there. You'll note that we don't just define an appeal as where a party appeals a decision of a lower court to a higher court, because this doesn't demonstrate that we understand the meaning of appeal. So, in your definition, highlight the word review and make sure that you use this word whenever you are defining an appeal. As we've seen, either the plaintiff or the defendant can appeal a decision of a lower court to a higher court in a civil dispute. Whichever of the plaintiff or defendant brings the appeal, that party is called the appellant. The other party, that is, the party against whom the appeal is made, is referred to as the respondent. Note also that it is a party which brings an appeal against a court's decision. It is not correct to say, for example, that the trial division appealed its decision to the Court of Appeal. Instead, it is a party to the case before the trial division that can appeal the decision of the trial division to the Court of Appeal. Now, in the diagram that you've already included in your summary books, you have a number of examples of appeals in the Victorian civil court hierarchy. First, a party can appeal a decision of the magistrates' court to the trial division, or a decision of the county court or trial division to the Court of Appeal on a point of law, that is, where the party believes that the lower court has made an error of law or has misapplied the law. Second, a party can appeal a decision of the county court or the trial division to the Court of Appeal on a question of fact, that is, on the basis that the lower court has misinterpreted or overlooked some important evidence. And third, a party can appeal a decision of the county court or the trial division to the Court of Appeal where that decision is about the amount of damages awarded by the lower court to the plaintiff. The plaintiff would appeal this decision of the county court or trial division to the Court of Appeal if it felt that the damages were too low. On the other hand, the defendant would appeal this decision of the county court or trial division to the Court of Appeal if it felt that the damages were too high. Now, you can see why we need to have a Victorian civil court hierarchy for there to be appeals. If you didn't know what courts were higher or lower than other courts, you wouldn't know what court you could appeal from or to. Using the counterfactual, if there was no civil court hierarchy then, we could explain this reason for having a Victorian civil court hierarchy by saying, if there was no civil court hierarchy, then there would be no appeals because there would be no higher courts and no lower courts, and so a party would not be able to have a higher court review a lower court's decision. That brings us to the end of this video on the Victorian civil court hierarchy. You should now be able to do two things. First, you should be able to describe the civil jurisdictions of the Victorian court hierarchy. And second, you should be able to explain the reasons for a Victorian court hierarchy in determining civil cases, including administrative convenience and appeals. Remember, there's one more thing that you have to do. Please make sure that you read the pages from the textbook referred to on the first slide. And if you find any additional information from those pages that you think is useful, make sure you supplement your Cornell notes with that additional information. Thank you very much for your attention.